Good evening to the aspirants of the JCJ 2022 main examination. Karibu sana in Kiswahili. In English, you are welcome to the class because the 2 days or 3 days gap, if I have not been mistaken. And let you resume it. And the class would be today and tomorrow would be there, but no class would be on 24th. Please note the point. The participants, anyone can unmute and read what I posted on the screen. Participants, anyone can unmute and read what I posted on the screen so that I could know that you are with me and I am with you. Both are traveling the same boat to reach to the destination. Yes, the thing which I posted on the screen is Namaskar, good morning, Assalamu alaikum, Habariza Subi. It is a Kiswahili language, and Vanakkam. These are the things would be there, especially addressing the morning, but even though it is evening, it doesn't matter. So, Civil Procedure Code, Bear Act. So it is me, that is the Professor Dr. Mohammed Saheb, Professor of Law, School of Law, St. Augustine University of Tanzania, Mwanza, Tanzania, East Africa. Yes, the part one that we dealt it, and we have covered up to this extent in my 3 days class back. That is the decrease in special cases. I put the asterisk mark also. Let us read. Participants, anyone can unmute and read that what I posted on the screen, which I highlighted. Anyone can unmute and read. Okay, there is some problem. It seems, okay, I read myself. In a lawsuit for the recovery or the process of the regaining or repossession of an immobile property, within parentheses real estate, the decree shall include a description of such property so that it is sufficient to recognize or identify it. So the special cases, it should be noted that in a lawsuit for the recovery of the process of the regaining or the repossession of an immobile property, suppose the property you have given for the lease or mortgage, then you have to revoke the property as soon as the mortgage period is over or the lease period is over. The decree shall include a description. Even the decree will give the description of such property which a person is going to get back so that it is sufficient to recognize or identify it. So the identification is very must in the decree. That is called the decrees in special cases. In a decree for the movable property, that is the personality within parentheses, it must mention that the exact amount of the money to be paid as an alternative in case of the delivery is not made due to any reason, whether it is a reasonable or appropriate. In case the movable property is not given over there, then the exact amount, the worth of it, at least that should be returned back. And that is it's the decree in the special cases. In a decree for the payment of the money, okay, money decree is concerned, the court may order that the payment of the decreal amount, that is the amount mentioned in the decree shall be, the 2 points should be noted over there. Number one, postponed, which is delayed to a future date. Suppose we can postpone it. Yes, we can postpone, which is delayed to the future date. In any case, it's delayed over there, we can postpone it. Number two, made by the installment, we are without the interest. In case a difficult situation should be there where the special decree can be passed, it can be postponed for the future date, number one. Number two, made by the installment. An easy installment can be made or with or without interest. Of course, that will be specifically mentioned in the decree. Is it clear? Participant, is it clear? Say yes or no. So, in a suit for the recovery of the process of regaining or repossession of the immobile property, in a suit for the recovery of the process of regaining or the possession of the immobile property, the court may pass a decree for possession or gaining of the property. Of course, the court will give clearly the possession or the gaining of the property, or in case of the immobile property where it cannot be made it clear at the time, it can be equivalent amount will be paid to the decree holder. So for the past rents are mesne profits. The mesne profits are the profit that can of an asset received by a tenant in a wrongful position and recoverable by the landlord. Suppose if he is possessing the property and he is taking the rent or any other, or he is irrigating it or harvesting it in it, whatever the amount would be there, that is called mesne profit. That should be given to the landlord. That is the final decree in respect of a rent or a mesne profit. in accordance with the results of such inquiry as mentioned. So the mesne profit means no one can become illegal at the cost of the others, whatever the amount which he got it, while retaining the property without returning to the decree holder. At that instant, that should be shared to the decree holder. If the decree holder is a landlord, it should be shared to the landlord. Whatever the harvest should be there grown in the period which is possessed by the judgment debtor. Let us see the Rule 12, capital A of the Code of Civil Procedure 1998. It states that a decree for the specific performance of a contract or for the sale or lease of an immobile property, which can also be termed as a real estate, shall specify the exact period within which the amount of the money or another sum is to be paid by the purchaser or the lessee. So in the attachment, the specific performance is concerned, where the decree is given over there, the money should be very much clearly written over there, either with or without the interest. And that also we should be specifically mentioned. So that is the Rule 12, capital A says. Now let us see the participant. Anyone can unmute and read. What is the Rule 13? Participants. Okay. The Rule 13 of the Code of the Civil Procedure 1998 states that the final decree shall be passed or delivered in accordance with the result of the preliminary inquiry. It says clearly, what is that? The Code of the Civil Procedure states that the final decree shall be passed or delivered in accordance with the result of the preliminary inquiry. Of course, after the result of the preliminary inquiry, then the final decree can be passed. That is in a lawsuit for an account for any property, either movable or immobile, or for the due administration under the decree of the court, before passing a final decree, the preliminary decree result should be given over there, or based on that thing, the decree can be passed. The court shall pass a preliminary decree ordering the account to be taken and inquiries to be made. So, a decree can be passed based on the preliminary decree and its results. That is the Rule 13 says. Yes. Now let us see the Rule 14, what it says. Rule 14 says, anyone can unmute and read what is the Rule 14? Participants, anyone can unmute and read. Rule 14 of the Code of Civil Procedure 1998, it states that a decree in a preemption suit, it is a suit where the displacement of a lower jurisdiction's law when they conflict with those of a higher jurisdiction, where the purchase money has not been paid into court, shall specify a particular day on or before which the purchase money has to be paid, and direct that on a payment to a court, the defendant shall deliver the property or to the plaintiff. But if the payment is not made on a specific date, the lawsuit shall be dismissed with the cost. In cases the court has settled upon rival claims to preemption, the decree shall direct. Of course, the preemption would be there, means the right would be given to the person, those who are adjacent to the land. Before he is selling the land to somebody else, he should ask the adjacent person. That is called the preemption. So, in a cases the court has settled upon a rival claims, means double claims are there, or set off is there, or the preemption is there, the decree shall direct. The small word is, the claim or a defense of each preemptor shall take effect proportionately if the claim decree are equal in a decree. If the claimant is the decree, the claimant in the decree is equal, then it should be proportionately given, followed in the decree. Proportionate amount of the 50-50 is there. The second bullet is clearly says, the claim or the defense of the inferior preemptor will not take place till the superior preemptor fails to make a payment of the claim, decree, or different in decree. Either the same decree or the different in a decree, the proportionate amount will be there 50-50. If the claim amount of the first one is there, then the first one, superior one, should have to, if he fails to make a payment, if the claim decree are different in decree. The second point claims it, the claim or a defense of the inferior preemptor will not take place The inferior preemptor will not take place till the superior preemptor fails to pay the payment. Suppose the superior preemptor fails to make the payment of the claim, decree, or in a different decree, then only preemptor will do it. Preemptor will not take place till the superior preemptor fails to pay. So, if the superior preemptor fails, then only the preemptor will make the payment of the decree. So that is the actual meaning of it. Is it clear? Okay. So now let us see how in a lawsuit for the resolving the partnership or taking the partnerships are concerned. In a lawsuit for the resolving the partnership or taking the partnership accounts, the court can pass a preliminary decree before passing a final decree, declaring the exact shares of all the parties. So before the passing the final decree, the thing is the preliminary decree will be passed and declaring the exact shares of all the parties. If the parties are the shares are there, fixing of a particular day on which the partnership shall become a dissolved, where the partnership is dissolved over there, that will be taken into consideration. If the partnership is dissolved, for fixing the day on which the partnership shall become dissolved and directing the accounts to be taken and other necessary actions to be done. So, in dissolving the partnership, how it can be taken? So, the preliminary decree before the passing the final decree would be made it over there. Next, what it says in a lawsuit for accounts between a principal person and an agent. A lawsuit for the accounts between the principal person and an agent, the court can pass a preliminary decree before passing a final decree directing the accountant that has to be taken. It can also be provided a special direction in regard to the mode of taking the accounts as well. So a preliminary decree would be passed for taking the account before the passing the final decree. So, in a decree passed in a lawsuit for partition of the property, either movable property or immovable property, or separate possession of a share in the property, at that instant, the decree shall declare the right of the several parties interested in the party, but shall direct, of course, they will count all the people, shall direct the partition or separation be made by collector in as in other cases of the immobile property, in case the estate is assessed to the payment of the revenue to the government. So, in case of the partition would be there, where the claims will be made with the different parts, then the claim should be clearly mentioned or mutation could be done, and that could be done by a collector, how much the portion in the mutation each person of the family will get it. Once it is registered over there, then only it can be either auctioned or sold or whatever the transaction further it can be done. So there all the decrees would be taken into consideration. Now let us see. The court shall pass a preliminary decree. Of course, generally, when you file a case, the preliminary decree will be passed, declaring all the rights of the parties in a state and giving a necessary direction, and then the final decree is passed. So, final decree will be passed at that instance only when the preliminary decree cases will be confirmed, then the final decree will be passed. If separation or the partition cannot conveniently be made without further inquiry. So, either the separation is concerned or the partition is concerned, then definitely the inquiry should be made. Who are the legal heirs? That is first and foremost will be made. Then only, and who are the people, those who are having claim over such a property? It would be ascertained over there. Once the legal heirs are ascertained, then the role of the collector would be there. They will say of course, collector and even the Tahsildar, and these are all the people who will take it if it is a mobile property. A decree where the defendant has been allowed or leave or start with a counterclaim against the initial claim of the plaintiff shall state with what amount is due to the plaintiff and what amount is due to the defendant thereafter. See, all that it depends upon when the defaulter would be there. When the defaulter would be there because of the decree, and then again you will file a case of the executive petition. So in that where it will be clearly mentioned how much the due amount would be there, that also will be cleared in the decree itself by showing its interest. I don't know whether you are following because you joined in the Munira, you joined in the middle. See, I am continuing from the last class. That is a decree of special order that I made it. How a special order decree would be made it over there. It is clearly mentioned how much the amount would be there, either with the interest or without the interest. When the partition is there, first and foremost, partition should be done, then only the decree could be made. Otherwise, that it cannot be made because there are many partners are there, or many family members are there. Okay. Of course, I sent it this file to you in advance. I don't know whether you read it or not. Munira, give me the answer. Did you read this
Sir, I
which I
didn't.
sent in the WhatsApp group?
No, sir. Sorry, I didn't read that, sir.
Yeah, but what is the use of sending to you?
Sorry, sir.
Okay,
Next time I
okay.
will check,
Because
sir.
sending it, because I know that there will not be continued classes would be there because I traveled. Now I'm taking class from New Delhi and staying in my
Sir.
professor house,
Sir.
Dwaraka. Mhm.
Sir.
So now let us see the judgment. What is meant by judgment here? Because what is the sequence in the three? Can you tell me? What is the first one? What is the second one? What is the third one?
First judgment, sir. Next degree will follow, sir.
Very good. Next, last one is?
Sir, last one. And pronunciation of the judgment, sir.
No, order.
Order, okay, sir. Thank you.
Yeah, that is the sequence. So now let us see the judgment. Because one photograph I have shown you, I asked why I have shown this photograph. Nobody has given the reply. Did you see the photograph?
Avun, sir. Chusna, sir.
That is my wife photograph. But what is the purpose of it? Nobody has given the answer. Huh?
Don't know,
Is
sir.
it a
Please,
difficult
sorry.
task?
Tell me, sir.
Is it a difficult task? That's my question. Hmm? See, again, I will show you here.
I will see, sir.
See, this is the photograph I have shown you. I asked why I shown this purpose of it. Nobody has given the reply. Can you tell me?
Sorry, sir.
Okay, I will give the back.
Ah,
Background, what is there?
yes, sir. Train.
Its train is there.
Yes, sir.
Did you see a double-decker train?
Yes, sir. Yes, sir.
That is a double-decker train.
Yes, sir. Where is it, sir?
It is New Delhi to, it goes to Jaipur.
Acha, okay, sir.
See, you could see here where the cursor is here, there is a stairs. And these panes are downstairs. And this is upper stair.
Okay,
Upper panes. See, here you could see the windows, and the up also you could see the windows. It is a double-decker train. That's what I want to show it. The purpose of showing is, of course, a lady would be there standing at the back and other thing.
Sir,
It is a double-decker train.
Sorry to interfere, sir, but in group, sir, you only allows only admins to message, sir.
See,
So
that I say, what is the purpose of sending the photograph? That I asked.
Yes, sir. So that's why anybody are not replace, sir. That's why.
Okay. No matter. The observation is very much important factor. Okay, let us come to the point of the judgment is concerned. The term judgment is defined in section 2. Can we say it's a class 9 or subsection 9?
Class 9, sir. లేదు, sir. Subsection 9.
When you say in the section 2s, generally we read it is a class 9. That is the wording that you used it. Yeah, right. Okay, why doubt? See, I made it very much clear here what we should are supposed to say. After section 2 is concerned, then we made it. Yeah, appendix, these are things. Yeah, here it is given. It is what is the section 2? Here, definition section 2. When section 2 is there, see that there is the tail is there here. In this act, unless there is anything repugnant in the subject or context, if any tail would be there, then naturally we can say it is a class. Am I right?
Okay, sir.
It is a class. So section 2, and what do you say? Class 9 of the Code of Civil Procedure, 1998. A judgment contains the facts of the case, okay, the issues involved, the evidence brought by the parties, finding on the issues, based on evidence or arguments, and every judgment shall include a summary of the pleading and issues finding on each issue. There is a ratio decidendi or the obiter dicta and the relief granted by the court. I don't know whether you know what is the ratio decidendi and obiter dicta.
Ratio decidendi means reasons for the decision.
Which can be followed as a precedent.
Yes, sir.
But obiter dicta is only on the special case, in this case only. It cannot be followed as a precedent. So, on a daily basis, numerous judgments are pronounced and various cases are disposed of. So, a judgment is having the everything, facts of the case, issues are there, pleadings are there, evidence is there, and the summary is there, ratio decidenda is there, finding is there, whether dicta is there. So, all these things will be there in the judgment. Judgment plays a very important role in the working of our judicial system. If a person wants to know the caliber of a judge, let him read his judgment. Then his caliber will be known. So a judgment plays a very important role in the working of our judicial system because they act as a precedents for the cases to come in the near future. Because they are taken, the judgment is taken as a precedent. Is it or not?
Okay, yes, sir.
So a judge in the judgment pronounced always states the reason for such a decision. A judge will not say plaintiff won, defendant lost. No. He will say a plaintiff won because of these grounds and the defendant lost because of these grounds. That is called having the face value. He should keep the face value, why he lost and why he won. The reason should be shown over there. The grounds will be shown over there. So now let us see the pronouncement of judgment. How a judgment will be pronounced. The word pronouncement means to make an official public announcement. Can he pronounce in the microphone? Or can he pronounce in the public? Where he will pronounce the judgment?
In the open court, sir.
In the open court, he will pronounce the judgment. The pronouncement of a judgment means that after the hearing is completed from both the sides, after the court has heard the pleadings of the parties or the arguments, the judgment shall be announced by the judges in an open court, either at once or at some future date. Of course, sometimes they will say judgment reserved.
Yes,
I
sir.
don't think that he can reserve the judgment for the 2 months, 3 months. There is a time limitation is
There
there.
is a time, sir. Limitation time is there.
Yeah, there is a time limitation would be there. Within that span that he should pronounce the judgment. After providing a due notice to the parties or either land councils. So notice should be given over there. So when the judgment would be there, both the parties should be present?
Yes.
Answer is
Yes,
yes.
sir. Yes, sir.
What about the council? Council should also be present.
Although they also present.
Yes. If a judgment is not pronounced immediately, then it must be pronounced within 30 days from the date of the conclusion of the hearing. So conclusion of the hearing there, the 30 days period is that you should have to make it out. In any case, you should not cross the 30 days for the judgment reserved. Is it clear?
Yes, sir.
However, sometimes it so happens that due to the exceptional and some extraordinary reasons like a bank holiday or strikes or some other situation, it may be delivered within the 16 days from the conclusion of the hearing. Some extraordinary days are like COVID is there. When the COVID is there, how could he could make it a judgment? So
Yes, sir.
suppose if it is a virtual one is there, then definitely he can make it out. If it is a virtual.
Yes.
So it is not mandatory for a judge to read out the whole judgment, and it would be enough if only the final order is pronounced. Of course, he cannot read the from front to the last, but the final order is pronounced, that is enough. The judge shall put the date on which the judgment was pronounced. So there will be specifically date would be there, and there when the judgment is pronounced, along with his signature, and signature also be must along with his signature. So, Rule 2, Order 20 of the Code of Civil Procedure 1998 provides a judge with the right to pronounce a judgment which is already written but is not pronounced by his predecessor. It's a judge with the right to pronounce the judgment which is already written but is not pronounced by his predecessor. So that is another point would be there. Suppose a judge will be transferred over there. What will be the position?
Next judge who was appointed in his place, he can pronounce the judgment.
Yes, that is the only the thing because he cannot come back and pronounce it. Am I right?
Yes, yes, sir.
So after the Amendment Act of 1976, the time limit was provided between the hearing of the argument and the pronouncement of the judgment. Prior to the amendment, no time limit was provided, and such a time limit was provided because there was indefinitely a continuous imposition from all over India. Yes, because earlier there was no time limit, but amendment brought it. But in any case, it's 30 days. But in extraordinary cases, because of unavoidable things, which is not in the control of human agency at the time, it is the 60 days.
Okay, sir.
Then what about the copy of the judgment? With the copy of the judgment will be given to the parties freely, or they have to pay the amount. Now let us see that once the judgment is pronounced, the copies of that particular judgment should be immediately made available to the parties on payment of cost as specified by the party applying for the copy. So there is a rule and regulation is there that depends upon how many pages of the judgment would be there and how much amount would be deposited of such charges as may be specified in the rules and orders made by the High Court. Of course, the rules and regulations were made by the High Court. And the attested copies, who will sign it?
Attested copy, sir?
Yes. Is it the Sharishtadar, or is the superintendent, or is the bench clerk?
Superintendent, sir?
I think there is a head of the institution would be there, he will sign it. And that section, and that court. Not it will be adjusted by the same magistrate who signed on it. Is it clear? A superintendent, a concern like a Sharishtadar or Nazar or superintendent, whatever the big boss will be there next to the judge.
Yes.
Next to the
criminal cases, there is no cost, sir. Accused will be given that judgment of free of cost, sir.
Achha, in the free of cost.
In the free of cost in criminal cases.
Okay. All right. Suppose if it is convicted also, it will be given, is it not?
Free of cost, sir.
In
Convicted
acquitted also, it will be given.
Yes, sir. Yes, sir.
Or only convicted, it will be given.
Acquitted or convicted, sir, judgment will be given
Doesn't
to
matter.
accused or anyone for free of cost, sir.
Is it there in the advocate's rules?
If there any third party will apply, then there will be cost. You should have to pay, sir. I think so.
No, is there in the criminal practice rules? It is there.
Yes, sir. For third parties.
Okay. Because unless until there is no such a provision, one cannot act arbitrarily. Is it not?
Yes,
So,
sir. Yes, sir.
yeah, contents of the judgment, according to the Rule 4, Order 20 of the Code of Civil Procedure 1998, a judgment of a court of small causes are satisfactorily if they contain the points of determination and the decision therein. Okay, what are the contents of the judgment will be there? Judgment of other court shall contain, okay, number A, summary of the pleadings, which is a concise statement of the case. Okay. Next, B, read the B1.
Issues which are the point for determination. C, finding on each issue and the decision thereon. And D, ratio decidendi, reasons for such a decision. And E point, the remedy which is the relief granted.
Yes. So number one is the summary of the pleadings should be there, and the B is issues which are the points of determinations and the findings of each issue, what happened, and the decision thereof it. In each issue, it will be clearly mentioned. And the ratio decidendi would be there. I told you it can be taken as a precedent for the other cases. And the remedy which is to the grief, what is the relief granted would be there, even that also be clearly mentioned in the judgment. That is the contents of the judgment. And the alteration of your judgment. Now let us see, once the judgment is dated and signed by the judges, it can only be altered or amended if, what are the conditions when it can be altered? There are mathematical or clerical errors are there. Even clerical errors are there, refers to the errors made by the clerks, and arithmetical errors like addition and minus, that is the division is there, multiplication is there. At that instant, the errors made in the numbers such as in additions or subtractions or multiplication and divisions, and there are errors due to the accidental slips or omissions. The errors take place when some essential element is left unnoticed. At that instance only the judgment can be altered. That is in the section 152 on review also, it is section 114. The judgment can be reviewed or settled or altered. Now, what is the foreign court and foreign judgment, which is clearly mentioned in the section 13 of the CPC? The Indian Code of the Civil Procedure 1998 CPC clearly mentions that procedure for the enforcement of the foreign judgment. What are the procedures should be followed there for the enforcement of the foreign judgment and the decrees in India? The CPC 1998 section 13 clearly defined the following as section 2 and clause 5 of the foreign court, which says, means foreign court means, read this one, foreign court means
Foreign court means court situated outside India and not established or continued by the authority of central government.
yes, any court which is situated outside the country where the authority of the central government would not be there, then we can say the foreign court. Section 2 class 6 of the foreign judgment means the judgment of a foreign court. A judgment given by the foreign court, pronounced by the foreign court, is said to be the foreign judgment. So, if you have studied the private international law, we will study recognition and enforcement of the foreign judgment. That I think once I shown you the article which I written, the recognition and enforcement of the foreign judgment between the two countries, that is Tanzania and Kenya. I wrote an article that was published in the Law School of Tanzania Journal. Okay, now let us see the nature and the scope of the foreign judgments. Section 13 embodies the principle of res judicata in foreign judgment. And it embodies the principle of the private international law. I told you clearly, private international law where the foreign judgment plays a very important role over there. That a judgment delivered by the foreign court of the competent jurisdiction can be executed and enforced in India. As it is. When such a judgment is given by the foreign court, competent foreign court, without any appeal,
it is executed in India.
Yes. Another is any such a judgment not in contravention with the local statute or the acts.
Local law and international law too.
Yes, yes. And any such a judgment will not in contravention with the constitution, or any judgment which is not contravention with the international instruments, and where it is executed over there, that country would be the party and ratified the judgment and domesticated the judgment.
Yes.
So these are the points would be there where we can consider it. Then we will see the object of recognizing the foreign judgments. Why we should have to recognize the foreign judgment? Can you tell me?
సార్ అది ఒక కాపీ తీసుకుని వస్తే అది ఒక జడ్జిమెంట్ మాదిరి కన్సిడర్ చేస్తారు ఫారిన్ కోర్ట్ అని ఒక ప్రిజంప్షన్ తీసుకునేది సార్ ఇక్కడైతే మనకు సిపిసిలో. కానీ ఆ ప్రిజంప్షన్ అనేది డిస్ప్లేస్ చేయొచ్చు అని చెప్తుంది కదండి సార్.
Yeah, number one, to save the time. Number two, make it easy because the system of the law is the same as the system of law here. If you say the general principle of contract, it's anywhere in India the same general principles.
Yes, yes.
When you see the private international law, the legal system will change it. But if any right which is a right which is created, and that right will not be generally will not be against the system of any other country, because rights are created all taking the consideration, including the morality, including the ethics, including the humanity. Am I right?
Yes, sir.
So it is very clearly mentioned there. If any judgment or right is created, would be there, the same right will not be extinguished in other country, and the same right and the judgment will be as it is taken into consideration, and the judgment will be given in the country where they have the local standi. That is called forum convenience, jurisdiction. Generally, the person who goes to the court, that country jurisdiction will be given to him to file the case. So that is the point. If a person who goes to the courts in the private international law should not come with the empty hands. So object of the recognizing the foreign judgment means the judgment of the foreign court is enforced on the principle that where a foreign court of the competent jurisdiction has adjudicated upon a claim and a legal obligation arises to satisfy that claim is the country where the judgment needed to be enforced. So the rules of private international law of each state differ in many respects, but by the comity of nation, see, this is one of the theory we will use it. Comity of the nation. The comity of the
Yes.
nation means I respect your judgment and you respect my
You respect. Yes, sir. Yes, sir. This makes sense.
reciprocal in nature.
Yes,
Suppose
sir.
if I go to your house and if you offer me a milk, naturally, when you come to my house, at least I should have to offer the milk. Even I don't have, I can borrow the milk from the other people. Am I right?
Yes, sir. Yes, sir.
But when you offer the decoction, is it a committee?
No, sir.
It's no. So that is the committee. I respect your judgment. You respect my judgment. Then the same thing will be applied at the nation of community. And sometimes no obligation on the nation to follow the judgment, because that is a justice. Because that is a justice.
Okay,
So there is an obligation also there to follow it. So comedy, theory of comedy is there, Western interest theory is there, and homogeneous is there, and we have at least 5 to 6 theories are there. Based on that thing, we can decide it which country and which substantial law can be used over there. When the dispute comes of the two nations where the subjects are hailing from the two nations. Always two nations are must in the private international law. Okay.
Yes, sir. Okay, sir.
Through the part of the judicial system of each state, these common rules have been adapted to adjudicate upon the dispute involving the foreign element and to enforce the judgment of the foreign courts or as a result of the international conventions. But I will write to the Bar Council of India to keep this a core course. Private international law is a core course in all entire Tanzania or entire East African countries. Earlier, it was only an optional course. I am the first person who introduced the private international in the entire Tanzania. Otherwise, it was restricted only to the prospectus. Jai Hind.